told our committee very specifically, we talked about brand stretching as a marketing strategy, and that's what this amendment is about. So we heard that brand stretching is effective in increasing brand awareness to help increase consumption, and that permitting cannabis brand elements on products such as ball caps and T-shirts is not in keeping with a public health approach because they may be reasonably seen by young persons who may find them appealing. This amendment, as I've put it, was recommended by the Non-Smokers' Rights Association, who testified that loose interpretation and limited enforcement of whether or not an item is appealing to young people or associated with an attractive lifestyle. That's what this represents. Health Canada's note in Senator's briefing binder identifies skateboard and guitars as off-limits. But, of course, caps and T-shirts would not be off-limits. Experience with the tobacco industry has demonstrated the creativity of producing products that gain cachet among young people, such as lines of clothing, and these would violate the spirit of the law. This amendment would not prohibit the use of cannabis brand elements on cannabis packages or cannabis accessories, and would not interfere with product differentiation in the retail environment. So it would remove a portion of text from the bill. Let's see now if I need to, I'll give you the amendment and then you could look at the lines that would be deleted. I do want to give you one more piece of witness testimony that I think we all remember very well from Professor David Hammond when we talked about the dangers about media and the influence of brand stretching. He said, and I quote, "I think it's worth noting for those of you who have been following the media that several cannabis companies have already gone on record stating that they intend to stretch the existing regulations as far as possible through things like augmented reality technology and brand stretching for other consumer products. The general rule is you need to restrict brand stretching if you want to restrict youth promotion and lifestyle advertising." He said that to our committee just a couple of weeks ago. So I'm proposing now to amend Section 17, parenthesis 6 of Bill C-45 to prohibit the use of cannabis brand elements on items that are not cannabis or accessories, regardless of whether or not they would be considered appealing to young people or be associated with an attractive lifestyle. That would be Clause 17, page 19. So I move that Bill C-45 be amended in Clause 17 on page 19 by deleting lines 16 to 27. And you probably, I hope, have those in front of you.
Page
Good.
19.
Thank you.
Other comments?
Agreed.
Let me ask the officials about the implication of removing this whole section. Does it sort of throw it up in the air as to whether this element is allowed or not allowed, or how does it work if it's not in here at all? Okay.
I can help answer that question, Mr. Chair. So the way the provision works is that there's a blanket prohibition against all promotion that is set out at Clause 17. And then the way the part works is there's a series of exceptions to that prohibition. So the subclause 6 creates an exception to display brand elements on things that are not cannabis or cannabis accessory. So some of the unintended consequences of removing this section, for example, would be the Ontario Cannabis Store wouldn't be able to put their brand logo on a sign outside of their store. The way the provision is crafted is that it is similar to what exists in the Tobacco Act and now the Tobacco and Vaping Products Act, which says that the display of these brand elements can take place, but not on anything that is associated with a young person, that is associated with a particular way of life, or where there's reasonable grounds to believe that it's appealing to a young person. And there's another dimension to this, which I'll turn to my colleague at the other end of the table, with respect to the potential charter implications of this provision.
So there are these provisions, the thing that is associated with a young person, et cetera. So those provisions that are in the Tobacco Act are in here now.
That's correct. And this provision, this exception, is similar to a similar exception which is in the Tobacco Act.
So, yeah, so it's fine the way it is. And in terms of its relationship to the Tobacco Act. Yes, no?
Yes, and in that light, the Department of Justice has assessed the bill in its entirety for consistency with the Charter. And the restrictions here that have been placed on freedom of expression have been found to be consistent with the Charter. I can't speak to further restrictions. Those may have broader implications than we can assess.
Okay. You ready for voting on this thing? All those in favor of JS8, the amendment of Senator Seidman? Recorded vote? Okay. All those, recorded vote.
The Honourable Senator Eggleton,
No.
the Honourable Senator Bernard,
No.
the Honourable Senator Dean, l'Honorable Sénatrice Mégy, the Honourable Senator Munson,
No.
the Honourable Senator Omidvar, the Honourable Senator Patterson,
Yes.
l'Honorable Sénatrice Petitclerc, the Honourable Senator Platt, l'Honorable Sénatrice Poirier, the Honourable Senator Seidman, the Honourable Senator Stuart Olson. Yeas pour 5, nays contre 5, 5, abstentions 2, 2.
So it loses on a tie. Okay, that takes me into JS9 rather, which is, again, Senator Seidman. Page 22 in the bill.
Clause 26, page 22. So the committee heard evidence from witnesses, ourselves, and from the Standing Senate Committee on Legal and Constitutional Affairs that THC potency is a significant predictor of harm from cannabis products, including negative mental health outcomes. The committee also heard that consumers should be provided with accurate information about the THC content of cannabis products to help make informed decisions and to protect the most vulnerable, including youth and persons with mental illness. While it is expected that regulations under Bill C-45 will require THC potency to be clearly indicated on the product label, this requirement is not enshrined in law, which witnesses told the Legal and Constitutional Affairs Committee would send a clearer message about the dangers and help protect the government from legal action. That is, if it's in law, that this should be required. This amendment would make it illegal to sell cannabis in a package or with a label that does not set out the THC content expressed as the percentage of the THC the product yields and by unit or dose based on how the product is represented to be consumed. So, and you should note that this amendment is separate from other proposals to set a maximum level of THC content. And this amendment comes from a unanimous recommendation from the Legal and Constitutional Affairs Committee's report on C-45. The policy director from Canadian Centre on Substance Abuse and Addiction said to Legal and Constitutional Affairs, "I completely agree that the level of THC and other cannabinoids, so CBD as well, should be clearly indicated on the packaging." And the chair of the Committee on Consumer Protection of the Barreau de Québec said, "You are going to tell me that it's possible to operate such warnings by way of regulation? We at the Barreau de Québec believe that the government has to be more severe than that. It has to set standards in the Act that will warn society about the dangers of using marijuana for the simple reason, as an example, not to be stuck with a class action against the government 10 years from now, stating that you should have warned us, and now you're liable and we're suing you. So, it's therefore proposed to amend the bill in order to ensure that THC levels be clearly indicated on labels affixed on cannabis products and its derivatives. That would be in Clause 26, page 22. And I move that Bill C-45 be amended in Clause 26 on page 22 by replacing line 23 with the following. Daring, semicolon, parenthesis D.1, that does not set out the tetrahydrocannabinol content expressed as the percentage of tetrahydrocannabinol the product yields, and by unit or dose based on how the product is represented to be consumed, semicolon, or.
Yeah. Questions? Anyone?
I'm just curious, you talk about clarification. I'm really interested in what you're talking about.
Mm-hmm.
How would a consumer with these new guidelines or percentages know any better? What would it say on the label that would help to really understand what he or she is buying?
Yeah, so this isn't saying anything about maximum levels or percentages. It's really, what is it saying is that there must be a content expressed on the label, specifically the percentage of THC that the product yields, and by unit or dose based on how the product is represented to be consumed. So, but it's not saying it should be this amount or it should be this amount. It's not proposing a maximum or minimum, but it's very clearly saying that you cannot sell cannabis in a package or with a label that doesn't set out the THC content.
Okay.
Right. Of course.
And what the effect may be. Thank you.
The officials? Mr. Costin, I guess.
Thank you, Mr. Chair. Again, I think you've heard from us a few times now. We don't disagree the government position on the importance of THC, and I would add THC and CBD on the label is something that many of the witnesses that you've heard, the task force made it a very, very clear recommendation. I would, however, point out, so at 139K, there is a reg-making authority specific to label requiring information about potency. The government's proposal on regulations has been very strong in suggesting mandatory that every product that's produced for sale include THC as a percentage, and frankly, looking ahead to products that will not be smoked quantified in a slightly different way, that it be prominently displayed on all labels. So in many ways, the requirements that are proposed in the motion are echoed through the regulatory authorities, but the spirit of the point that's being made, that it is absolutely essential that consumers trust and understand the potency of the product that they're receiving is very consistent with what the government view has been for quite some time.
It's superfluous to put it in the bill? It's
it's there in a different form right now, and it's there in a form that allows, to a point that was made earlier, for the regulator to be able to quickly and adeptly respond to what we imagine to be a fair bit of innovation from an industry perspective. And so one of the other recommendations that we've received loud and clear is the regulator needs to be nimble as possible for adjusting to all sorts of things we can anticipate the industry to do in the future.
Okay, I have Senator Patterson and Senator Seidman down here.
Thank you.
Oh, I'm sorry, Senator Dean, you still had the floor. You called the official. Okay. Senator Patterson then.
Follow up to the witnesses' comments. We've heard, and you've just said that this important issue will be dealt with by regulation. Mr. Blair said earlier today that some regulations will determine whether matters are criminalized. He talked about the regulations being having strong penalties. I'd like to ask about this issue and also the other regulatory power. What scrutiny will be possible for Parliament for regulations, for the regulatory powers enabled by this legislation? How will Parliament, how will the regulations be reviewed and scrutinized? By Parliament or otherwise?
So as with many regulations, at least at Health Canada, we've got a robust process for regulation making, informed by significant public consultation, and ultimately under the purview of the Governor and Council, not Parliament. And so that's the way it is for the current medical cannabis regulations, and that's the proposal as it exists today for the regulations that would be made under the Cannabis Act. Is there anything you want to add?
I would add that the Senate is probably familiar that there's the Standing Joint Committee on the Scrutiny of Regulations, which has the mandate of scrutinizing every regulation made by the Governor and Council. And as well, senators may be aware that there is also a provision in the proposed bill that would provide for a review of the entire legislative framework, not just the Act, but also the regulations, 3 years following the coming into force of the legislation.
Okay, Senator Seidman.
It's true there is a committee called Scrutiny of Regulations, but everybody knows that committee is years behind. So the regulations get written and they don't get reviewed until years later. So that's a little unfortunate, and I think that's not what we're looking for. And with all due respect, it's very different to put something in a regulation as opposed to putting it in a piece of legislation where it's actually in the law. And I think that's what this is calling for, that we don't want to wait for regulation to be written on the off chance that it gets written and it gets written right. We want to see it in the law, that it would be illegal to sell cannabis in a package or with a label does not set out THC content. You know, and that's what we're asking for.
Yeah, Mr. Costin, again.
One point of clarification, and I believe my colleague also wants to add something. Then I would just maybe offer, perhaps the senators may wish to give some consideration to the treatment of hemp in the proposed motion. Because of course, hemp products, separate and apart from the consumer cannabis that we're typically talking about, are both equally captured under the Act. And so the motion as written would require that all hemp products also provide this information, which through regulations we can do it a bit differently. But Deanne, I think, wanted to say something.
And to build on Mr. Costin's comments, from a legal perspective, what the concern could be here is that tetrahydrocannabinol, there are many of them. There's more than Delta 9 or Delta 8. And currently, we're not aware of all of the numbers, and it would be very broad. And to ask a licensed producer to list all of these may be in some ways very almost impossible.
Okay. Senator Dean?
Yes, well, I think that we're going to be talking about this again a little bit later. I'll just say the following, that there has been extensive work conducted on an approach to regulation that is quite exhaustive. We've all had a chance to look at the proposed regulation. I think we can trust that the government is going to do what it set out in the proposed regulations. In general, I would say that, and many of us know this, regulations are a valid, often used part of the architecture of government policy implementation. They permit change and adaptability in response to changing circumstances, and we've just heard a good example of that. We think we've got it nailed by referencing one constituent and then later find that we have more, and we have to amend the legislation to fix that. That's why regulations are adaptable, and that's why they're important. It is unusual in the context of regulation to go to this level of granularity in in a statute, and for that reason I will be opposing this motion.
Senator Stewart Olson, followed by Senator Platt and Senator Seidman.
Thank you, Chair. And I do sit on that committee, so on the scrutiny of regulations, and I am telling you it is years is correct. But I haven't seen the proposed regulations. So, but you know, if you buy a bottle of liquor, beer, or whatever, right on the label it says how much alcohol. And I don't see a problem with making sure that if people are going to buy this product legally, they know what they're buying. And that's I think that ingredient, tetrahydrocannabinol, I think that's really important to have that on a label so that you know what you're getting. Anyway, that would be my input.
Senator Platt.
Just a question for Senator Seidman. Did you say at the outset this was unanimously passed by Legal and Constitutional Affairs?
Yes, that is. This is an amendment that was a unanimous recommendation from Legal and Constitutional Affairs.
I expect they have a few good legal minds on there as well.
I suspect they did. Thank you.
Yeah, Senator Seidman.
Yeah, if I might, since Mr. Costin brought up the hemp issue, and I would be more than happy to have a redraft of this amendment excluding hemp from it, if that would be an improvement that would make this amendment acceptable.
Well, you're right. It's up to us, not the official, to
That's what I'm
determine
saying.
whether it's acceptable or not.
Yep.
Okay. Senator Patterson, and then a question from Senator Langton.
Just a very quick question. If I may, through you, Mr. Chair, ask Senator Dean. You said we've seen the regulations? Did I hear you say we've seen the regulations?
The proposed regulations, yes.
Who's we?
Well, they're publicly available, all of us, if we cared to look at them.
It's a consultation paper, but there are no regulations.
I thought the legislation enables the drafting of regulations.
Indeed it does, and that too is not uncommon, that a piece of legislation creates the ability to make the regulations. However, I understand that, and officials will talk to this better than I, that the government wanted to get, as it should, in a planned way, ahead of the proclamation of the legislation. It consulted, it sent out a consultation paper, and as a result of that, there was a report of the consultations which set out the government's intentions in terms of regulating potency. I'll ask if I've got it wrong, that officials will correct me.
Regulations. You said regulations.
They can't be regulations before the bill is passed.
That's why I asked the question.
Okay. Senator Langton.
Just a quick question to Mr. Costin. I heard you make a point, I think, and I wanted to see if I had it correct. You were concerned about the word percentage, where in the regulation it could be changed if over the course of time there's different measurements that are more appropriate than percentage, and particularly given the different kinds of product. Senator Seidman used the word content, not when she was reading the amendment, but when she was speaking. And I just want to know if that's an important distinction of content, if it was to be in the legislation versus regulation. I don't know how the committee will vote, but if that's an important distinction, that would improve this amendment.
Maybe I can try and help answer the question or the discussion a bit on 2 points, Mr. Chair. The first is to clarify that the Health Canada and the Government of Canada put out a regulatory proposal in March which specifically spoke to the packaging and labeling requirements that would be required under future regulation should the Cannabis Act be approved by Parliament and receive royal assent. And in that, there was an annex of actually about 2 pages which detailed the requirements for the display of THC and CBD by different classes of cannabis and by different product forms, whether or not the product was intended to be inhaled in a bulk form or whether the product was in a discrete form, so a capsule of cannabis oil, for example, then the requirements are different. So when it comes to a capsule of cannabis oil, the requirement is to indicate how much THC in terms of milligrams is in each capsule, as well as the total amount of THC in the package. Whereas when it comes to dry cannabis, then the requirement was to label it with the percent THC content. And to my colleague's point about the different forms, there's a distinction between THC and THCA, which is often referred to as the acid form. So THCA is actually not active. It doesn't cause the psychoactive effect until it's heated. And so we want to make sure in the regulations that there's no trickery going on by the industry, that they label only THC and not the THC or vice versa, that they actually have to label the amount of THC that the product can yield under its intended use, so if it's heated or burned. So that's the type of complexity the proposal is set out, and why the legislation provides for these regulation-making powers, so that the regulations themselves can address the different specific circumstances to achieve the exact policy objective that is behind the proposed amendment.
Senator Pratt. Thank you. It would be useful if I quoted the recommendation by the Legal and Constitutional Affairs Committee. The recommendation reads, ensure that THC levels be clearly indicated on labels affixed on cannabis products and its derivatives, as recommended by the Quebec Association of Psychiatrists and provided for by the proposed approach to the regulation of cannabis, in order to protect the most vulnerable, including young persons and people with mental illness. So the recommendation did not say that the act should be amended.
Thank you. Senator Pettyclerc.
Just briefly to follow up on this, while I share many of the concerns of Senator Seidman, I think on a lot of levels, what we heard in committee is that we're going to have to be able to respond very quickly to newly developed products, variable products, which will be put to the market, and to respond quickly to make any possible changes to protect consumers, to protect our youth, and to protect adults who will be consumers of the products. I think it's by way of regulation that we can have this flexibility and speed, if you will, a quick response time to be abreast of any new products on the market. So I will not be able to support this amendment.
Were the regulations gazetted? In what gazette were the regulations published? Because we keep talking about regulations, and usually they're published in the Gazette. So there's the first and the second. So where have these regulations been published that we keep referring to?
Answer that, or one of your team there.
Well, because Bill C-45 is still under consideration before Parliament, and we don't know when and if it will become law, it is not possible at this point in time to even publish or make regulations. What the Department of Health Canada has done, however, is set out a detailed consultation paper and a detailed response to that consultation paper, so that those who are entering the industry will understand clearly what the labeling requirements will be.
But it's my understanding that usually there's a draft of the regulations published in as a first gazette, a draft of the regulations. And one of the biggest complaints of the stakeholders has been that there is no draft of the regulations published. There was a consultation, that's correct. But we all sit here not knowing what the regulations are going to be because there never was a draft of the regulations published as normally happens. So I guess that's my sense of skepticism about regulations, sadly.
Are we ready for the vote?
Yeah.
Okay. All those in favor of the amendment of Senator Seidman, please show their hands, unless you're asking. A recorded vote, yes.
The Honourable Senator Eggleton, PC.
No.
The Honourable Senator Bernard.
No.
The Honourable Senator Dean.
Nope.
L'Honorable Sénatrice Mégy.
Abstention.
The Honourable Senator Munson. The Honourable Senator Omenvar.
No.
The Honourable Senator Patterson.
Yes.
L'Honorable Sénatrice Petitclerc.
No.
The Honourable Senator Platt. L'Honorable Sénatrice Poirier.
Oui.
The Honourable Senator Seidman. The Honourable Senator Stuart Olson.
Yes.
Yeas, pour, 5, 5. Nays, contre, 6, 6. Abstentions, abstentions, 1, 1.
The motion is not carried. Moving on to JS 10, which is clause 33 on page 24. Senator Seidman.
Thank you. So again, this one is about THC potency, and we did hear evidence that THC potency is a significant predictor of harm from cannabis products, including negative mental health outcomes. And witnesses observed that THC potency of cannabis products has increased dramatically in recent years, and that consumers are likely to seek higher potency products in the recreational market. The proposed regulations will impose a potency limit for cannabis oil, 30 milligrams of THC per milliliter of oil, and require only a volume limit on the quantity of pre-rolled dried cannabis. This amendment would amend Bill C-45 to require that a maximum potency for all cannabis products be prescribed in regulation. Multiple witnesses told the committee that it's easier to introduce tougher restrictions at the outset of legalization than try to put the genie back in the bottle. Imposing maximum THC limits for all cannabis products at the outset of the legalization is a prime example where it would be very difficult to set limits in the future. So let's start with the best limits we can set now. Now, Senator Dean did suggest that there's a natural maximum of 30% THC for dried cannabis, so there's no need to set a limit. But not only is 30% THC much higher than what is considered by public health experts to be safe, it ignores the possibility that plants could be bred to produce dried cannabis with a THC potency of more than 30% in the future. This amendment proposes to amend the bill to impose a maximum limit on the THC potency of cannabis products to be prescribed in regulation. The executive director, Ian Colbert of the Canadian Public Health Association, said to us, to Sochi in his testimony, we would have liked to have seen maximum THC concentrations in the regulation. Our original paper on the topic called for a maximum limit of 15%, with exceptions for medical purposes, if there were extenuating circumstances. And Dr. Harold Callant, Professor Emeritus in the Faculty of Medicine at the University of Toronto, told us, I'm puzzled as to why Health Canada did not set strict limits on the maximum concentration of THC in preparations to be used medically. It is even more important to limit that concentration in preparations used non-medically, where there is no supervision of how and how often and how much is used. So, page 24, clause 33, I move that Bill C-45 be amended in clause 33 on page 24 by replacing line 20 with the following. Cannabis of any class that is not referred to in Schedule 4 or that has a potency exceeding the prescribed maximum potency.
Anybody else on this? Senator Dean?
Comment from officials, please.
Sure. Is this in the same category as the previous one? This is bringing a regulation into the, into the bill.
Chair, to a large extent, yes, and the senator sort of reflected this in her introduction that, in our proposals, particularly when it comes to certain forms like certain types of cannabis. You know, the question that was asked earlier, it really, questions of potency, maximum limits, portion sizes, all these things are very particular to the mode of ingestion. And what makes sense for one mode doesn't tend to make sense for the other. So it has to be a very kind of textured treatment. And if you like, my colleague can elaborate on some of the technical elements of it. So I think with respect to the motion, when we look at the schedule and the 5 classes of cannabis that are set out in Schedule 4, certainly some forms already, as my colleague at the end of the table kind of indicated, already will be subject to limits through the regulations. In others, the limits will be different. So the mention of dried cannabis was in the Senator's comments. And then I would also look at, when we start thinking about the application of this amendment for something like a cannabis plant or even cannabis seeds, which are also set out in the schedule, defining and determining what the potency limit, what an appropriate potency limit might be, is something that we would, that frankly is not a very easy thing, not a very easy thing to do. John, is there anything that you want to add?
Yeah, I think that, when we think about potency of dried cannabis, when we think about the potency of cannabis generally, we tend to always go back to the amount of THC in dried cannabis. And so, again, the government's intention is to absolutely, with the spirit of the motion, to ensure that there are limits on the amount of THC set out in the regulations, but it's the application of those limits to, for example, cannabis seeds themselves, which would not contain any THC, would just pose a challenge.
Okay, Senatrice Meiji.
Comme pour le JS. For GS9, I have the same concern with respect to the regulation because although Petit Claire said that would allow us to move very quickly if we wanted to change things, I do have some concerns. So it's the same concern, the caveat that I expressed earlier with respect to the earlier intervention.
Just for anybody else before who hasn't got the first time? Okay. Senator Seidman?
Yeah, well, this is about the regulation. So this isn't an amendment that the THC potency should be in the law. It says this amendment imposes amends the bill to impose a maximum limit on the THC potency of cannabis products to be prescribed in the regulation. So it's saying there should be a maximum limit. It should be prescribed in the regulation. That's what this amendment says.
Legal?
It was a minority recommendation from legal.
Okay. Are you ready for the vote on this? I got some advice to give you. We have a change. Senator St. Germain is now substituting for Senator Bernard. We have the appropriate form to that effect. Show of hands vote, or all those in favor?
Could we have a report, please?
Sure.
The Honourable Senator Eggleton, PC.
No.
The Honourable Senator Dean. Sorry, Senator? No. L'Honorable Sénatrice Meiji. The Honourable Senator Munson. No. The Honourable Senator Omidvar.
No.
The Honourable Senator Patterson.
Yes.
L'Honorable Sénatrice Petitclerc.
No.
The Honourable Senator Platt.
Yes.
L'Honorable Sénatrice Poirier. The Honourable Senator Seidman. Yes. L'Honorable Sénatrice Saint-Germain. The Honourable Senator Stuart Olson.
Yes.
Yeas pour 6, nays contre 5, 5, abstentions, abstention 1.
Okay, so that's carried. So now we have. Did you change your names yet? So Shell Part 1, Division 2, entitled Other Prohibitions, which contains this clause 16 to 39, carry as amended. Is that agreed? On division. Okay. So we now go to Part 1 of Division 3, which, did I get this right?
No, it's actually just, there's one.
Well, there's one amendment in this section. It's on page 26. This is, if there ever was a technical amendment, this is it. It's putting in a comma. So.
15.
Agreed. Okay. Thank you.
Okay, agreed? Oh, it's on division again. How
So
about
you
that?
can ask the question.
Okay, so this then is the only amendment to clauses 40 to 43, which is Division 3, and shall Part 1, Division 3, titled Obligations, which contains clauses 40 to 43, carry as amended. Division, just for a comma. Okay. All right. So that leads us to Part 1, Division 4. And so we would have, in this case, JS 11. Oh, that one's gone because, yeah, the home cultivation one. Okay. Then we have TD 4. Now, TD 6, 7, and 10 also relate to this as well, but we'll just deal with them as we come. TD 4, Senator Dean.
Start talking about tickets and a more effective non-criminal approach that provides incentives for early payment and disincentives for late payment. The first one deals with an early payment option. The proposed amendment would establish an early payment option for individuals issued a ticket under the Cannabis Act, giving the accused the possibility of paying less than the amount identified in the ticket, and would include a statement to this effect in the information portion of the ticket. So I move that Bill C-45 in Clause 51 be amended by A, adding after line 28 on page 30 the following. D1, a lesser amount than the amount determined under subsection 4 that may be paid for the offence if it is paid within a specified period that is shorter than the period referred to in paragraph D, and B, replacing line 30 on page 30 with the following, within the period referred to in paragraph D or D1, and in subsequent consequential amendments we'll be seeing other references to D and D1.
We will indeed. Anything further, Senator Poirier?
Question of clarification, Senator Dean. Did I understand right that if somebody would get a fine and they would pay it earlier, that they would get a reduced amount? I'm just wondering what the fairness is of that for people who live in remote areas and may not have the ability to pay it as quickly as somebody that lives in an urban area?
Well, if there's access to internet-based service or phone service to pay tickets, as there is in many places, there would be equity. If that isn't the case, then I would probably look to officials to provide further advice on that. I think this is a good faith effort to incent early payment. And,
but Senator, I feel that's still a discrimination. That's assuming everybody has an internet or access to an internet, and I can tell you in remote areas, some places don't even have the towers to have internet, let alone to be able to get on the internet if they even know how to do it. I just feel it's we're treating one group of people differently than we're treating another group of people, and I have concerns about that.
Well, we'll hear from the officials on this. Mr. St. Denis.
Thank you, Mr. Chairman. The early payment option is not limited to payment via the internet. It can be done by telephone, and it can be done by mail, and then ultimately it could be done in person. So there are a number of possible avenues for prepayment.
So, okay. Anything further on this? Is this agreed then? On division? Is it all those in favor? Let me see a show of hands, just to be sure. Okay. Those opposed? Okay. On division. Carried. TD 5, again, Senator Dean. This is linked to TD 8, 9, 11, and 14.
Yes, and this relates to another change in ticketing where there is a shift away from convictions to an absolute discharge on a plea of guilty, so that with that absolute discharge there would be no record that the person would walk away with an absolute discharge, which would not have consequences at the border and not have consequences for employment applications. I'll move it. That Bill C-45 in Clause 51 be amended by A, replacing lines 31 to 34 on page 30 with the following. 1, a finding of guilt will be entered into the judicial record of the accused, and the accused will be deemed to have received an absolute discharge and not to have been convicted of the offence. The judicial record of the accused in respect of the offence will not be used for any, and we can get an explanation of that. And B, replacing line 37 on page 30 with the following. 3, if cannabis has been seized in relation to the of. So, again, this is one that essentially would give an accused who receives a ticket the option of voluntarily. Let's see, I've got the right one here. Yeah, I mean, in essence, the shift is that the accused, if pleading guilty, would have an absolute discharge, and that moves us away from a conviction, which to some extent or another would have some element of criminality attached to it.
Okay. Any other comment on that? Is that agreed? On division? Carried. TD 6, that depends on TD 4. TD 4 got passed, so.
Amendment flowing from the preceding amendment, move that Bill C-45 in Clause 51 be amended by replacing line 5 on page 31 with the following, referred to in paragraph D or D1. And so that's a consequential amendment.
Okay. Is TD 6 then agreed to? On division, carried. TD 7?
Move that Bill C-45 in Clause 52 be amended by replacing line 23 on page 31 with the following. Accused within the period referred to in paragraph 51, 3D or D1 constitutes A.
Okay. Another technical amendment. Is that agreed? On division, carried. TD 8. Senator Dean.
TD 8. Technical again, move that Bill C-45 in Clause 52 be amended by replacing line 23 on page 31 with the following. Sorry, is this 7 or 8? Sorry. 8, sorry.
TD 8.
Sorry.
Just adopted TD 7.
That Bill C-45 in Clause 52 be amended by A, replacing lines 26 and 27 on page 31 with the following. A finding of guilt is to be entered into the judicial record of the accused, and the accused is deemed to have received an absolute discharge and not to have been convicted of the offence. B, replacing lines 29 and 30 on page 31 with the following: offence must not be used for any purpose.
Okay, anything further? Is that agreed? Agreed on division. TD 9.
Move that Bill C-45 in clause 53 be amended by replacing lines 9 and 10 on page 32 with the following: offence must not be used for any purpose that.
Okay, any further comment? Agreed on division. I get my little language right here. TD 10.
Move that Bill C-45 in clause 54 be amended by replacing line 14 on page 32 with the following: the ticket within the period referred to in paragraph 51(3)(d) or D1 the AC.
Okay, anything else? Okay, is that agreed to on division? Oh, now, alrighty. Am I moving into another section?
No, you're in the same section.
Still in the same section. There was one thing I did forget here. I have to go back to Division 4. There was nothing in Division 4. Pardon?
Just say Part 1, Division 4.
Yeah, oh yeah, Part 1, Division 4, miscellaneous. Shall Part 1, Division 4 entitled miscellaneous, which contains clauses 44 to 50 carry? We didn't have any amendments to that. On division, okay. So we'll continue then. Most of what we've been doing now is in Part 2, and ticketable offenses is the area we've been dealing with here. Okay, so JS 12, Senator Seidman.
The committee heard evidence from witnesses and from the Standing Senate Committee on Legal and Constitutional Affairs that the 30-day time period to pay the fine associated with the ticket, that is for possession of over 30 grams up to a specified amount, marginalizes and discriminates against the poor. The committee also heard evidence from witnesses and from the Standing Senate Committee on Legal and Constitutional Affairs that the 30-day time period to pay the fine is not long enough for those living in remote areas, including in the northern regions and in Aboriginal communities. And this amendment comes from a unanimous recommendation from Legal and Constitutional Affairs of their report on Bill C-45. So we did hear from Michael Spratt of the Criminal Lawyers Association. Our committee, so she heard. The ticketing provision is good in that it can divert adults away from the criminal law process, and it is good that it seals the court records so that some of those criminal collateral consequences don't follow adults down this ticketing path. However, we know that youth are excluded and the poor will continue to be marginalized and discriminated against through this ticketing regime, because you can only take advantage of getting a record sealed if you're rich enough to pay the fine within 30 days. There is not a clearer case of discrimination or an unconstitutional provision. So, I am proposing to amend the bill to increase the allowable period to pay a ticket following conviction. That would be Clause 54 on page 32. I move that Bill C-45 be amended in Clause 54 on page 32 by replacing line 22 with the following: D parentheses, the accused has 60 days after the day of conviction.
Comments? Anything on that? Senator Pratt, is that what Legal Constitutional Affairs said? You're our authority, I gather, here today. Okay. Shall this motion carry? Carried. So that's carried. Now we go to TD 11.
This is a little bit more substantive, so just give me a minute. The proposed amendment is consequential to an amendment to remove the requirement that judicial records of a ticket conviction be kept separate and apart from judicial records. The importance of this is that when this involved a conviction, the existing language in the bill would suggest that that conviction should be kept separate and apart from other judicial records. The government heard from provinces and territories that would be hugely onerous, in some cases impossible, The fact that we've now moved to absolute discharge actually precludes the need for that record to be kept separately, thus being responsive to a concern raised by provinces and territories. That being the case, it's moved that Bill C-45 in Clause 54 be amended by replacing lines 32 and 33 on page 32 with the following: accused in relation to the offence must not be.
Okay. Anything further on that? That agreed? On division, carried. TD 12.
Okay, this is an amendment that, for the purposes of equity, extends a provincial provision to territories, and the provision deals with delaying licences or permit issuances where a ticket has not been paid. So this is at the back end, where we have unpaid tickets and delay, and I move now that Bill C-45 be amended by adding after line 40 on page 32 the following: licences, permits, etc. If the amount paid under this part is owed to Her Majesty in right of Canada, the person responsible by or under an act or ordinance of the legislature of a territory for issuing or renewing a licence, permit or other similar instrument in relation to the offender may refuse to issue or renew or may suspend the licence, permit or other instrument until the fine or fee is paid in full, proof of which lies on the offender.
Okay, anything further on this? Okay, is this agreed? Carried, on division, I guess. Okay, TD 13.
This connects with the early payment option.
Yes.
Move that Bill C-45 in Clause 58 be amended by A, adding after line 18 on page 33 the following: B1, a lesser amount than the amount determined under paragraph 51(4)(a) or B, as the case may be, that may be paid for the offence if it is paid within a specified period that is shorter than the period referred to in paragraph B. And B, replacing line 20 on page 33 with the following: within the period referred to in paragraph B or B1.
Okay, anything further? That agreed, on division. TD 14.
This one relates back to the absolute discharge. Move that Bill C-45 in Clause 58 be amended by A, replacing lines 21 to 24 on page 33 with the following: 1, a finding of guilt will be entered into the judicial record of the accused, and the accused will be deemed to have received an absolute discharge and not to have been convicted of the offence. 2, the judicial record of the accused in respect of the offence will not be used for any. B, line 27 on page 33 with the following: 3, if cannabis has been seized in relation to the off.
Okay. Anything further on this? All right. Is this agreed? Carried. On division. Okay. Okay. As always? Okay. TD 15.
Again, consequential that Bill C-45 in Clause 58 be amended by replacing line 31 on page 33 with the following: referred to in paragraph B or B1, the accused must appear in.
Anything further on that? Agreed? Agreed on division. Yes, yeah, gotcha. Okay, so that brings to the end the amendments on Part 2 under ticketable offenses. So, my question is, shall Part 2, entitled ticketable yes, well, another couple of hours, it'll be pronounced quite differently, won't it? Which contains clauses 51 to 60 carried, as amended, carried. Is that agreed? On division. Okay. So, we're now into Part 3, which is licenses and permits. And the first amendment up is TD 16.
This is the first of a cluster of amendments that would provide greater flexibility to the minister in the enforcement world, so that a minister in the enforcement activity could move beyond, in some cases, what is outlined in regulation. The first moved that Bill C-45 in Clause 62 be amended by replacing lines 26 and 27 on page 37 with the following conditions. Minister, subject to the regulations, the minister may make a licence or permit subject to any conditions that he or she considers appropriate, and that's on a case-by-case basis. And that would include cases where there are no conditions imposed by a regulation, so more flexibility in the enforcement world.
Okay, anything else on this? Okay, is that agreed? Carried on division. TD 17.
In the same light, that Bill C-45 in clause 64 be amended by replacing lines 13 to 17 on page 38 with the following. Any cannabis specified by the minister if the minister has reasonable grounds to believe that the suspension is necessary to protect public health or safety, including to prevent cannabis from being diverted to an illicit market or activity, or B, where any prescribed circumstances exist. So the proposed amendment provides authority for the minister to suspend a licence or a permit under prescribed circumstances which go beyond those specified in the statute, similar to provisions in the bill where the minister has authority to refuse a licence renewal or to revoke a licence in prescribed circumstances. I think just the kind of flexibility that we'd like the minister to have.
Okay, so TD 17, anything further on it? All right, agreed on division? Carried. TD 18.
That Bill C-45 in clause 65 be amended by replacing line 22 on page 39 with the following, being cancelled.
Oh, okay.
So this, I think, is a translation only. And this is, again, the proposed amendment would ensure consistent wording throughout the bill when describing the cancellation of a security clearance by replacing the word revoked with cancelled in the English version of 65F and replacing the word revoqué with annulé in the French version.
Okay, anything further on TD 18? Is that agreed? Carried on division. TD 19.
The next relates to security clearances. That Bill C-45 in clause 67 be amended by A, replacing line 31 on page 39 with the following. Security clearances 67 sub 1. Subject to the regulations, the minister may grant, or B, adding after line 33 on page 39 the following. Security clearance is required by minister. The minister may specify by name or position any person other than a person specified in the regulations who must hold a security clearance if the minister is of the opinion that the person performs, has performed, or is about to perform activities related to a licence or permit that's issued under this part, or that is the subject of an application under this part, or B, has had or is about to have custody, management or control of the place where activities related to a licence or permit that is issued under this part or that is subject of an application under this part are being or will be performed. Notice 3. If the minister specifies that a person must hold a security clearance under subsection 2, the minister must provide the applicant for and for the holder of the licence or permit related to that person with a notice to that effect in writing. So, in essence, the proposed amendment would provide the authority for the minister to specify additional persons or persons that would be required to hold a security clearance beyond those explicitly identified in the regulations.
Okay, any further comments on TD 19? Senator Poirier.
For clarification, are we basically here clarifying the power of the minister, and or are we giving more power to the minister, and is this consistent to other acts or other situations?
I believe, I will just say, I think we're giving more flexibility to the minister to deal with extenuating circumstances that involve security than might be in the regulations, but I'll ask my colleagues, the officials, to comment.
Sure, thank you. I think that's a fair characterization. Not only this committee, but many of the other committees heard I think, significant testimony about how certain criminal organizations will seek to influence the operations of companies from several steps removed. And in response to some of these concerns, our testimonies of others, have pointed to the vetting of individuals who occupy certain specified positions in the company that we've identified that we will identify through the regulations as being of particular influence to the operations of that committee, that company, and therefore potentially vulnerable to influence. This additional authority simply acknowledges that there may be positions other than the ones foreseen in the regulations where the minister makes a determination that there's a point of vulnerability and the person occupying that position requires a security clearance.
Is this consistent in other acts?
Deanne, is that something you can...
This type of security clearance process in statute is rather rare. There are things for air transport, for example, but a lot of it is policy-based. So I don't think I have an easy comparator. This is consistent with the intent of the security clearance process.
Okay. Anything else on this? Okay, TD 19, Gillette carry on division. Yeah. Okay, well that completes that section on license and permits. So my question is, shall Part 3 entitled License and Permits, which contains clauses 61 to 68 as amended, carry? On division. Is that agreed?